Good morning. My name is Simon Beaver. I'm a partner at Wardle Daly Bernstein Beaver, which is a litigation boutique in Toronto. And I've been asked to speak to you this morning about courtesy and good faith. It's a topic that I think has been getting more and more attention over the past few years. And so when I was asked to speak on this topic, I wasn't quite sure where to start. So I thought what I would do is go back to first principles and start to figure out where the obligation to act with courtesy and good faith comes from and what it actually means. And so there are a couple places where I looked to start to prepare for this. And then what I think I'd do is step through the rules very briefly with you. And then talk about some of the recent case law that has dealt with courtesy and good faith, and in particular, the dealings that the Law Society of Upper Canada has had with Joe Groya recently, which I think have been in the news, and the Divisional Court just released a decision on it. So if we start with where the obligation for courtesy and good faith comes from, I flipped through the rules of professional conduct, and it seems like there's a rule that sets it out. And the rule is interesting for a couple of reasons. It's in Chapter 5, which is titled The Relationship to the Administration of Justice, which I thought was an interesting place for the obligation of courtesy and good faith to come from. I took it that the Law Society put it there because, in its view at least, the obligation of courtesy and good faith is a necessary component to the administration of justice. It's not just something that we're preached to do because it's professional or for some other reason. It actually matters in terms of administering justice.